Assalamu alaikum and welcome to Perspective. We'll be talking about, as far as the Supreme Court is concerned, certainly there seems to be a division of opinion there. We'll be talking about the overall ramifications of what 184.3 and the fact that, of course, now there's legislation on it. Also, what this means for the judicial process, what it means for the political process when such an important case also hangs in the balance. Also the powers of suo motu, the powers under 184.3, their purview, their ambit, all of these questions, and also there seems to be an overall agreement at this time for the demand for a full court to decide this very, very important matter. All of these considerations, of course, the case is now moved to Monday. What happens in the next few days will determine certainly a course of history, so to speak. All of that today on Perspective. I have with me Aniq Zafar, who's a political analyst. Thank you for joining us today. We have with us Hafiz Ahsaan, khokhar, who is a legal expert, also advocate Supreme Court. Thank you for being with us today. We also have with us Ul Farooq from the PML-N. Thank you for joining us. Ji, Aniq Sahab, we were earlier talking about, the issue has now become multifold. There's the issue of 184.3, the ambit of power, all those things. There's also a very important issue of elections now. How are you looking at this overall, and the fact that, you know, what this means for the institution itself as far as the Supreme Court at this time is concerned? There seems to be a division of opinion there, a rather vocal division of opinion. How do you look at it?
Look, the first thing is that this division in institutions is a reflection of the overall divisive politics that is undergoing in the society, in the country. That is now tearing apart almost all institutions. There is a wide disconnect between different players, different stakeholders, and that is the real trouble here. When it comes to the Supreme Court, we have seen in the past the history of the Supreme Court that such incidents have happened in the past, in 90s, at the time of lawyers movement, when the then Chief Justice Iftikhar Chaudhry was removed by President Musharraf, and now we are again seeing a situation where Honorable Chief Justice of Pakistan is aligned with a certain point of view, and it is being alleged that he is aligned with a few judges, brother judges, and they sit together in most of the cases and decide with a certain political view. That is what is being alleged right now. On the other hand, there are other brother judges who are now objecting the way benches are being constituted.
But has this been an issue, I mean, from time to time? Let me come back to you. I'm going to go to Hafiz Sahab also. Ji, Hafiz Sahab, this has become, as far as the ambit of 184.3 is concerned, from time to time there has been, there have been questions on the Chief Justice's unfettered power to take suo motu. Isn't that true?
Absolutely right. The purpose behind drafting 184.3 is the add-on jurisdiction to the Supreme Court of Pakistan, because primarily the Supreme Court has the original jurisdiction, then it has the appellate jurisdiction, then it has the advisory jurisdiction. So the framework of the Constitution has provided a window to the Supreme Court of Pakistan if there is any...
To override all of those, or it encapsulates all the...
If there is any issue relating to the public interest or the enforcement of the fundamental rights, the Supreme Court can exercise jurisdiction under Article 184.3 of the Constitution. So this is a constitutional provision. Now with the passage of time, these constitutional provisions, giving on either side, start from the enforcement of the fundamental rights, entered into the area of the political questions and regarding the eligibility of the certain, the appointments in the country. So that hurts so many in the legal fraternity as well, and on the politicians as well. So with the last, we have seen start from the 2008 when Iftikhar Chaudhry Sahab again came into the Supreme Court of Pakistan. They took number of suo motu notice. One was the relating to even on the small issues. Then there was a voice from the bar associations and the bar councils that this provision has to be regulated. And in every reference which is being presented before the Supreme Court of Pakistan, while there is a Chief Justice outgoing or any judge of the Supreme Court, there has been a demand of the Bar Association. One Article 84(3) should not be unbridled. Number two, the appeal should be provided against the decisions of Article 184(3). And the third is very important, the appointment process in the superior judiciary, the High Court and the Supreme Court of Pakistan. So the government has taken a stance, but finally it would be subject to the decision of the Supreme Court of Pakistan if someone goes over there, whether the Parliament has the legal competency to legislate under Article 191 relating to the internal administrative affairs of the Supreme Court of Pakistan. But primarily the framers of the Constitution has given the mandate to the Supreme Court itself that they decide themselves about their rules or internal working, and under their administrative power they made the rules.
I want to come back and talk more about this, that you're saying that the ultimate power would again lie with the Supreme Court after
to the extent of their internal administrative affairs.
But this is an internal administrative affairs, is it?
Yes, of course, this is internal administrative affairs.
Okay, let me come back to you on that. Ji, Sadiq Ul Farooq Sahab, can you hear me? Ji, Sadiq Ul Farooq Sahab, your party is it true that there's largely an agreement even between you and the opposition, primarily the PTI also, that there should be a full court on this?
Of course. As you know, Imran Khan Sahab too has said that whether it is a larger bench or full court, for me there is no difference. And similarly, we stress full court, that a full court under the objective conditions, when there are fissures within judges, differences within judges, full court will help solve this problem, because all judges are brother judges. And Supreme Court, when we read 184(3), it also says Supreme Court of Pakistan. So Supreme Court doesn't mean only Chief Justice of Pakistan. As in Mustafa Impact's case, it was decided that Prime Minister is not the federal government. Federal government is the federal cabinet. So similarly, we feel and we believe that Supreme Court is all just judges combined.
Sadiq Ul Farooq Sahab, there's criticism by the opposition on the timing of the legislation, the way that it's been brought, the way that the Parliament has this time chosen, the speed in which it's been legislated upon. What do you have to say to that?
58 bills in half an hour were adopted during the government of PTI coalition government. We have given 2 days. But timing...
On that note, I think there's a problem with audio. I'll come back to you. Aniq Sahab, the same question to you. As far as the overall speed of the legislation is concerned, there is criticism on it. It is being said that the way that it was brought about, the way that it's being, the speed of it. How do you look at that overall? Like I said, the issue of 184(3), the ambit of it is a long-standing one.
This is a very long-standing issue, as Hafiz Sahab was also pointing out, that because the jurisdiction has been expanding. 184 has expanded into political questions, and it was basically for the enforcement of fundamental rights, but then it expanded into many constitutional and political affairs. And coming back to the point of the speed of legislation, obviously the legislation should not be passed with such haste. That is a principle which ideally should be followed. But when the state and society are going through such massive turbulences,
yes.
I think Parliament has to come up and come up with the solution which it thinks is better for that situation. Now Parliament has taken a step. We hope that it does not turn into a major clash between the judiciary and the Parliament, because that will be very unfortunate. Parliament has some right or not, that will be debated in the Supreme Court again. We are looking into it.
So I want to come into
I
that.
would like to point out here just quickly that 191 does say that the Supreme Court has the power to make rules and internal rules and regulations, but under the law and the Constitution. So the law is passed by the Parliament. Law has to be passed by the Parliament. Supreme Court itself cannot become a law-making body.
But 191, I mean, the ambit, whether it is an administrative power, whether, you know, those questions will have to be answered. How does it work? It will have to be a larger bench. It will have to be a full court bench. Is it one judge of the Supreme Court is enough? How will it work? Anybody can go to the Supreme Court.
Definitely, there will be bar councils, there will be political parties
because
which will be going
on this issue. Essentially, there is a division of opinion.
Ideal situation will be that it should be a full court that should decide it. If the past practice of putting it in front of a 3-member bench or 5-member bench continues, I think that will not work. That will create further problems.
Hafiz Ahsaan, do you see this, I mean, eventually landing in the Supreme Court again?
There are 3 aspects. One aspect is that Article 184(3) is mentioned in the Constitution. If the Parliament like to provide an appeal against the order passed under one article at 184(3), it is to be mentioned in the Constitution, and that has to be done through 2/3 majority by both houses,
which it's not, which at the present
which is not available. The second point would be that if the framers of the Constitution has given the mandate to the Supreme Court of Pakistan to internally make the rules under Article 191, so it would much be important for the Supreme Court of Pakistan. They heard the voices of the Parliament, the politicians, and the Bar Association, because in 1980 rules, Order 11 is very much clear that the rules has given the power to the Supreme Court Chief Justice that it is his power to constitute the bench and to fix the cases, including the cases of Article 184(3). And interestingly, Article 184(3) is not required under Rules 1980 that it is to be more than 3 members or the 5 members or the 7 bench. So more important would be now the Parliament has passed the legislation. It has a very good, the certain points is to some extent might be it would be challenged on the legislative competency and on the pending proceeding mentioned in Section 7 of the 2023 Act. So in all perspective, because the rules were made by the full court of the Supreme Court of Pakistan, and if this law is challenged to the Supreme Court of Pakistan, it would be much better that the Honorable Chief Justice of Pakistan would constitute a full court and decide and to address both points, that whether they have the competent, the Parliament, and second is if there is internal matter, then address all the issues.
But Hafiz, at present, what happened today, the proceedings that happened today, let's look back at that. It doesn't seem like till the end of the proceedings today, it doesn't look like there's going to be a full court on this.
Today there was a repeated request by the Attorney General of Pakistan to have a full court reference on this proceedings, but the Chief Justice of Pakistan he mentioned and to me that he has not accepted the stance of the Attorney General of Pakistan on 2-3 ground that the bench is not available, that we have heard the case for the last 4 days, so it's very difficult to constitute another bench and it will take some times. So there is no chance to me while seeing the proceeding in the Supreme Court of Pakistan, there will be a full court. And what happened on Monday, that will be up to the proceedings, that how the government will take his stance to the court, and what the Supreme Court having the 3-member bench will decide the request of the Attorney General or the other parties who made the request during the proceedings.
So they haven't formally declined it, you're saying?
They have not formally declined, but they have observed during the proceedings
that it's difficult.
Yeah, and they have also mentioned that that point will also be addressed while I hope making a judgment.
Let me go to Ul Farooq Sahab. I hope you can hear me now.
Yes.
Ul Farooq Sahab, now the demand, at this time of full court, the issue of suo motu is a long-standing one. Why take it up now in this manner as far as the PML-N is concerned? What's your stance?
Mahrukh, I think the controversy which has sprung can only be resolved once the full court hears this case. Otherwise, like-minded judges, such and such bench, such and such a person hearing the case, and uh, the judgment will come in favor of such and such party with this strength or with that strength. That won't be predicted, and I think all parties will be satisfied once the full court hearing starts, and
So, Ul
everyone
Farooq
who
sir, would you agree that it seems like the PML-N at this time has lost confidence in some of the very highest judges of the Supreme Court?
I think most of the political parties and even legal fraternity has lost confidence in one or the other members of the Supreme Court or brother judge.
But isn't it true, Siddiqul Farooq Sahab, that in the past we have had Chief Justices who've taken more suo motos on a variety of issues than at this time, in this instance?
At that time too, those Chief Justices were largely criticized by the society, by lawyers, by politicians. So that is not a good move, or that was not a good practice. At least we should follow other democratic countries where Supreme Court takes suo motu notice, and the full bench, the full Supreme Court takes this notice, not Chief
To
Justice
make it,
or
so that it becomes, there's no controversiality to the whole process at this time, which one or the other party will allege, whatever the outcome is.
Yes, of course.
Okay, let me come back to you. Aniq sir, by and large, would you agree that there is an overall agreement that the way that Panama happened, the results of Panama were not fair, and the way that this legislation will address that miscarriage of justice, as the PML-N is saying, is another issue? Primarily, there should be no objection to that. Do you agree?
Well, again, coming back to the jurisdiction of the Supreme Court, as it becomes really a question of legal probability if we are talking about someone getting an adverse judgment at the level of Supreme Court without going through other forums and does not have any forum for appeal. That is sort of, again, an infringement on someone's legal and fundamental rights, right? So to the extent of that, I think there is a fair point, there is a fair demand that if an adverse judgment which affects someone's life, someone's political career, or other issues at the level of the Supreme Court in case of a suo motu notice, then there should be a mechanism which allows that person to go for an appeal. Now, since such verdicts have been passed by 3-member benches or 5-member benches or whatever the constitution, the construct of the benches may be, in that case, I think again we will be going into an argument whether the appeal will be going to the same bench, or then we will have to go for a larger bench or a full bench in case of an appellate. If Supreme Court is to turn into an appellate forum against its own judgment, then it has to decide that whether it will be a full bench or what, because that will again be a question of administrative issues. But to me, this is a very justified and fair demand that there should be an appellate forum, because as we have seen in the past, some of the Chief Justices have used this power quite liberally, There are jokes in the society that chief justices have been questioning the price of samosa through these notices. So I think there is a need to sort of decide that.
But the question is, okay,
and
on
how far it
primarily
can go.
everyone probably, let me go to Hafiz Ahsaan. Hafiz Ahsaan, largely everyone, most people would probably agree that perhaps there needs to be a definition of this power. But the point is, should that definition come from the Parliament, or should it come from within the Supreme Court?
Article 184(3) itself has given the power and has described a power, that the power relating to the public interest and enforcement of the fundamental rights. And what are the fundamental rights? They are also given in the Constitution: right to life, right to liberty, right to property, right to access, right to equal opportunity. These are basically the fundamental rights given in the Constitution. If Supreme Court or any other court would take action on this, there will be no question on it. But now, despite our political differences,
but Hafiz Ahsaan, it's not a question only of political differences. It's a question of the voices that are being raised from within the Supreme Court. Because when we are seeing justices of the Supreme Court themselves say that you know, this power cannot be dependent on the solitary decision of one man. Questions, you know, comments like this, which invariably are you know, adding to the controversy at this time. So the problem is the voices from within the Supreme Court, because we've certainly seen the criticism coming from all over before also, as far as political parties are concerned.
Now we as a bar association keep saying to the Supreme Court of Pakistan, not once time but many times we spoke in the Supreme Court of Pakistan that this power should not be vested with a one man. And one man should not be given such a power that one night he takes the notice and decide on the other side. But now the situation is that more importantly, that political questions are being brought to the Supreme Court of Pakistan, and to some extent the suo motu notice bring political differences or the political questions under the garb of 184(3) of the Constitution. That makes a problem for the politicians and for the justice sectors related to the students. What is the solution now? The solution is that no political question, even it is more importantly there is a need, then it has to be brought to the Supreme Court of Pakistan.
Right, on that note, we have to take a short break. We'll be back just in 2 minutes. Welcome back. We just saw the former Prime Minister Mian Nawaz Sharif address the media also and address the people from London, and he categorically says that as far as the full court is concerned, it seems to be the end of all problems and all controversialities. With respect to that, let me go to Ul Farooq Sahab. Ul Farooq Sahab, can you hear me? Ul Farooq Sahab, Mian Nawaz Sharif Sahab just spoke to the people, he spoke to the media. It seems to be a solution. Do you agree, as far as the full court is concerned? The PML-N is saying that the kind of assertions, the kind of you know, things that are being said across the board from different political parties, what do you think is the objection to having a full court when it seems like that's an end to all problems for you know, there will be, as far as pointing fingers are concerned, as far as creating issues are concerned, this will end the problem in one go. Do you think so?
We have already stated that no one, even including Imran Khan, has said that he has no objection on convening of a full court session, you may say. So if full court starts hearing this case as a bench, I think everyone will be satisfied, because everyone, if there are one or two judges supporting one idea, other two judges supporting another idea, the majority is, overwhelming majority is neutral. So any judgment coming from overwhelming neutral majority will be accepted by all.
But Ul Farooq Sahab, unfortunately, when we may agree that that seems to be the solution, it doesn't look like you know, it's going to go in that direction at this time. Of course, you know, that's just the overall view. But if it doesn't, what is the PML-N's next plan of action? Are you going to accept the decision that comes forward if there is no full bench constitution?
So just see, Mahrukh, that the 3 members bench, which we see that is still intact, includes Justice Azad Ahsaan, who recused. What does it mean? A bench which starts from 9 members, then 7 members, then 5 members, then 4 members, then 3 members. So much changes and so much discussions. So does that bench serve the purpose of a 9-member larger bench? No, not at all. Now, today, Chief Justice, while telling his story of oppression, etc., burst into tears. That was just a suppressed anger. And these tears depicted a weak personality, painted a weak personality. So I think he himself should refuse to sit in this bench. And in my humble opinion, he needs complete rest for 2 to 4 weeks at least, so that he may become normal mentally.
Right. Ul Farooq Sahab, let me come back to you. Aniq Sahab, what do you expect will happen if, like, Ul Farooq Sahab is saying, it doesn't look like, and we were earlier also talking about, we don't know, but it doesn't look like there's going to be a full court on this issue. What kind of a political effect do you expect of this, whatever decision comes forward on Monday or Tuesday or subsequently?
Very unpredictable. Very unpredictable future lies ahead. Because, say, if the Supreme Court again says that the 3-member bench says that the Election Commission has to give a specific date, and it's not 8th of October as Election Commission has already said. Though I find some hope, since the Chief Justice has been asking for lowering the political temperature and has been asking a few commitments from all stakeholders to sit together, enter into a dialogue and try to come up with a solution which is acceptable to everyone. So maybe if that happens, election is moved forward by 1 month or 2 months or whatever. But if there is no engagement between stakeholders and Election Commission passes, the Supreme Court passes a judgment, and again after 15 or 20 days again there emerges a situation where the government, the Election Commission or other stakeholders say that we cannot hold elections, then we will enter into a very, very
because obviously then there's also the fate of the legislation and that going back to the Supreme Court also.
Yeah.
So you think
by that time legislation will be in force. That will take precedence over the current proceedings, because then that legislation will be challenged. It surely will be challenged. Then that will decide other fundamental questions. As for the full bench, that full bench may be able to decide this question of the election being held within 90 days or not. But other issues which are splitting the court, and there is division in the court between brother judges, those are not being addressed by a full court. Those are being addressed by some legislation, some internal discussion, whatever way.
Hafiz Sahab, is it possible, like Aniq Sahab is saying, and we've heard the CJ say that perhaps there should be some political dialogue, some kind of a political meet between different political parties. Is it possible that the Supreme Court may say that there is a time, of course, for the elections, but considering the circumstances, if political parties can sit together and come to an agreement, is that a kind of possibility in this?
There is a possibility, and the bench of the Supreme Court is repeatedly saying that there should be a political dialogue. All the political parties, they should sit together, and even the bench has asked to both sides that they should give their commitments regarding about the holding of the election and for the conduct of election. Because if we go in this way to the election in Pakistan, that will be a, it will be a big law and order situation in Pakistan. And to another extent, if there is no political dialogue, the things going on in a way, that would be another political crisis, and even the constitutional crisis is heading towards us. So let sanity should prevail. All the political parties should sit together, and before going to a final verdict of the Supreme Court of Pakistan, and very interestingly, that the issue before the Supreme Court is about the holding of election within 90 days or beyond the 90 days of the mandate of the Election Commission of Pakistan. But now all is stressing upon about the cognizance and jurisdiction of the Supreme Court of Pakistan. So it is another issue that the political questions and the non-dialogue between the political parties also dragged the Supreme Court in those matters which should not be in a democratic country.
Right, fair enough. Siddiq Ul Farooq Sahab, I'm running out of time, but I'd like to ask you this last question. You know, it seems like the ultimate end to the kind of conflict that we are seeing is political dialogue. Again, do you think that's a possibility?
I also support a political dialogue, but if all parties are sincere in it. But even if this question is referred to the full bench, I think the Supreme Court should accept the demand of Attorney General, then so many representatives of various bars, political parties, and go for making full bench, full court bench. It will also solve this problem.
Right, fair enough. Thank you so much for being with us. Unfortunately, that's all the time that we have. Thank you for joining us, Aniq Zafar Saab, Hafiz Ahsaan Khokhar Saab, Siddiq Ul Farooq Saab. Overall, of course, it seems like, again, there is, a controversial state of affairs for Supreme Court, Parliament, the issue of 184.3, the issue of elections that hangs in the balance. Of course, the ultimate solution, it seems, as far as the PML-N, the government is concerned, is full court, and that seems to be echoed by all parties. Barring that, of course, there is also an issue of a political dialogue that keeps coming up. Unfortunately, we are at this time not seeing a move in that direction at all. Perhaps the next couple of days will determine the course this will take. Thank you so much for joining us today on Perspective.